Well, welcome everyone. Good morning. We have a pretty good group of people here in the Bar Center. We actually had 23 people register to attend online, which we were excited about. I don't think all 23 made it here this morning, but hopefully they're online. So we also had 259 people online. So that's always makes us very happy. It's good attendance. So welcome to our, I think, fourth free CLE of the year that the State Bar is hosting. All of the hard work, and the real host, of course, is our LGBTQ plus committee, who works very, very hard, and they worked really hard to put this together. I think it's going to be a really interesting discussion, and they're one of our more active, most active committees, and we really, really sincerely appreciate that. This does, if you are online attending virtually, this does qualify for live attendance. And the reason for that is that you can put questions in the chat, and we encourage you to do so. We've spoken with our presenters, and their preference is to hold those questions until the end of each session. So we're going to monitor the chat, watch those questions, and give them to the speakers towards the end of each session. Excuse me. If you're attending here in person in the Bar Center, make sure that you sign in the sign-in sheet. That's the way that we make sure that you get the email for attendance, so you can claim your credit. And that email, we'll do our very best, because we're aware that it's at the very end of the reporting period. We'll do our very best to get that email out by the end of today. If we don't get it out by the end of today, it will be probably tomorrow. So don't panic if you don't see it by the end of the day, but you should see it very, very soon. So watch for that email from the State Bar. And it will have the link that you can use to claim your credit for attending today. This is going to be recorded, and it will be available for you viewing online in a few weeks. Remember, for those of you who are here in the room, remember that any noise that you make can be heard by the folks attending virtually. So try to keep that in mind when making noise. But if you do have a question and you're here in the room, make sure that when you have that question, speak loudly so the folks at home can hear it. That is very helpful for everybody. So with that, those are all the administrative things. I'm going to turn it over to Jerry Langan, who is a co-chair of our LGBTQ committee, and he's going to kick us off.
Very good. Well, good morning. Thank you, Mary Jane. Thank you, everyone, and welcome to our Pride Month CLE series on LGBTQ plus legal developments here in the Mountain State. I co-chair the LGBTQ plus committee with my co-chair, Caitlin Samuelson. Just a quick plug about our committee. We are the newest bar committee, now having been in existence for 2 years. We stood up in Pride Month of 2022, having been approved by the Board of Governors at the annual meeting in April of that year. Our mission is to bring and educate and promote awareness about LGBTQ plus legal issues and developments pertinent to West Virginians. We do that through a series of monthly newsletters that we distribute to our committee members, highlighting ongoing legal litigation developments pertinent to those issues. We do quarterly committee call-ins where we have discussions about various ongoing issues. We do a semi-annual outreach event to the law students at WVU College of Law. And we do an annual CLE event such as this, which we are delighted this year to bring about our first ever 3-part series on various issues that are pertinent to our committee and to the membership of our members. If you are interested at all in the concepts of non-discrimination, of diversity and inclusion in law firms, we encourage you to join our committee. You can send an email to myself or to Caitlin Samuelson. We would be happy to add you to our committee and involve you in our ongoing activities throughout the year. Please consider doing that. And I'd be remiss if I didn't start with some thank yous for the State Bar staff here, Mary Jane Pickens, our executive director, Kennedy Murphy, who's our events coordinator, Samantha Chase, the new CLE coordinator, and Andrew Eden, our IT coordinator. There's a whole bunch of stuff that goes on behind the scenes that people aren't aware of, and we're just really thankful for them. So on to our first session, HB 2007 and Transgender Kids in Care, a medical and legal update. I'd like to introduce Caitlin Samuelson. She, of course, is the co-chair of the LGBTQ plus committee with me. Caitlin is an associate at the Littler Mendelsohn Law Firm in the Morgantown office, where she specializes in employment law. She's a 2015 graduate with a bachelor's degree in religious studies and women's and gender studies from WVU, and a 2020 Order of the Coif graduate from the WVU College of Law. Probably her biggest accomplishment is that she's been able to co-chair this committee for 2 years with me and some of the harebrained ideas that I come up with. You should put that on your resume, Caitlin. But she's a brilliant legal mind. It's just a delight to discuss and review issues with Caitlin. And I'm just delighted that she'll be presenting along with our first presenter for the morning, Dr. Megan Gandy. Dr. Gandy is an associate professor and Bachelor's of Social Work Program Coordinator at the West Virginia University School of Social Work. Her scholarship, her research, her writing, her teaching interests are primarily focused on the well-being, the welfare, the health of the LGBTQ plus community. She's published, very well published in over 20 peer review articles and book chapters on various issues pertinent to these particular issues. She holds a bachelor's degree in psychology, a master's degree in social work, and her PhD in social work, with that terminal degree coming from Virginia Commonwealth University. Her approach is informed by 6 years of practice as a practicing clinician and licensed clinical social work. Dr. Gandy is perhaps one of our state's most preeminent experts on the issues that we're going to be discussing and exploring this first 50-minute session, and that being transgender kids in care. And with that, I would start with and introduce you to Dr. Megan Gandy.
Thanks very much, and thanks for having me. I'm excited to be here. I will go ahead and start our presentation. I do have some slides so that you all can follow along with me with the information that I have for you today. And if at any point you need me to slow down or speed up, just let me know. So, of course, oh, there we go. Okay. So as it was shared, we'll be talking about caring for transgender and gender diverse populations in West Virginia. I did create these graphics. I am very proud of that. However, I'm not a graphic designer, so no critiques, please. Who I am beyond the bio that Gerald gave me. You know, I come from this work both clinically and professionally and personally. I've been involved in grassroots advocacy and activism in 4 different states, North Carolina, Virginia, Oklahoma, and now West Virginia. And I come to it from a personal point of view as a member of the LGBTQ plus community. And so this work is important to me, and it's also important to the people that I love. So what are we going to do today? We are going to be talking about the basic components of gender affirming care, specifically healthcare. We're going to focus a little bit on care overall, but we'll narrow into medical care after a bit. And then we'll tie that into how recent legislation has impacted that care for this population in the state. One thing that this presentation is not is that this is not your gender identity 101 class. This assumes that you know the difference between sex assigned at birth and gender identity. It also assumes that you understand the distinction between sexual orientation and gender identity as distinct concepts. So if any of that is foreign to you, I encourage you to go on the internet and search those topics. And so, like I said, we'll start out just talking about gender affirming care broadly. And this is going to cover things that both children and adolescents might engage in. And then we'll go into best practices for medical care and end with some legislation discussion. So broadly, gender affirming care can be defined by the World Health Organization as can include any single or combination of a number of social, psychological, behavioral, or medical interventions designed to support and affirm an individual's gender identity. And I think that's a helpful definition because it gives us a lot of context for what actually goes on in gender affirming care. We can see that it can be one of those things. Some trans and gender diverse people just maybe want one of those interventions or two. Some people want all of those. Some people want none of those. And all of those are valid. And I think that that's a helpful context to have because I think there's a lot of misinformation out there. That's actually one of the goals of this presentation is to dispel some of that misinformation. And so starting out, there's lots of ways that we affirm someone's gender identity, whether they're transgender or not, right? And so when it comes to trans and gender diverse people, this definition is a great foundation. So what does that look like for people under the age of 18? So this is an individualized course of intervention. This is not the same for every child. Every child is very different in their gender journey. And so we need to really individualize that. And that's what we see happen in clinical settings. And so one thing that I think you all may be aware of, but it's important to really point out is that this is life-saving treatment. This isn't treatment that's optional for some children who have severe gender dysphoria. And we'll see in a few minutes about the consequences of not receiving the kind of care that these children and adolescents need. And so what do helping professions often provide if they're not a medical provider? People like social workers and lawyers might provide family support, and you can also help them with navigating the different life domains, maybe school or other family relationships, just helping them decide how are they going to navigate the social transition of their child. And then we also can refer to individual and family therapy, which is often a very useful supportive process. And then you can also refer to a medical specialist. And so what is gender affirming care for children and adolescents? And I'd like to kind of point out here that we have both two different columns going on, and that's because there's two different things that happen medically. For children who are pre-puberty, there's no medical interventions that happen. And that's one of the misinformation campaigns that were out there during the legislative session and beyond. We're just simply not doing experimental medical interventions on children. It's just not happening. What is happening is supportive counseling, talking to the child, talking to the family, and going on a journey. Gender identity development is a journey. It's not a destination. And so helping professions go along with the family and their child on that journey. That journey continues into adolescence, but the distinction is puberty. So once puberty starts, that begins the things that can't be reversed if we allow a child to go into their natural puberty. And that's why we use things like hormone puberty blockers, and we'll get into the scenarios that are appropriate for that. But just to kind of reiterate that supportive counseling doesn't end. We don't just say, all right, you've arrived at adolescence and now you're ready for more medical treatment. That evaluation continues continually by a team of medical experts. And so that does include medical treatment where appropriate, but it also includes lots more supportive counseling. And so what is medical care for adolescents who are trans or gender diverse? Once again, that I can't emphasize enough the fact that it's a continual evaluation. This isn't something where a child or their family are just walking up to a doctor, they get a script and they walk out. And I think that is a big myth that is being perpetuated. And so the second thing is that puberty blockers are a very vital part of this process, not only for children who might need a little more time to figure out what's going on with them with their gender identity, but also for adolescents who aren't yet ready to have that full onslaught of hormones. And so what we see is that adolescents who are in the early stages of puberty need to block that puberty that's happening before they're ready to start hormone replacement therapy. And so sometimes children, on the other hand, do need some more time. Maybe they're still developing, evaluating their gender identity, and they're not ready to transition one or the other. And so that just gives kids more options and parents more options, and it's a great medical intervention. And so then some adolescents do decide that they want to go into hormone therapy for a gender transition. And so another piece of misinformation is that this is happening in secret and parents don't know about it. Medical experts do not do that for any kind of medical treatment. You can't provide medical treatment to people under the age of 18 without parental consent. It is something that parents are involved in throughout the whole process. And so, is medical gender affirming care safe for adolescents? I think that one of the things that I see a lot of out there is that all this medication is permanent. And that's just simply not true. Puberty blockers are not permanent. They are sound medical treatment. We've been using puberty blockers for decades for lots of different common or uncommon childhood diagnoses, such as precocious puberty, endometriosis, and other things. But the one thing that is permanent is puberty. And so it is in the best interest of the child, if they are questioning their gender, to be evaluated by a specialist, and maybe gender puberty blockers are appropriate. Medications are never initiated until after an adolescent has begun puberty. And so that's why a child before puberty might need to go and visit the doctor, because they need to have labs drawn. They need to tell whether or not they're in a certain stage of puberty. But that medication doesn't begin until after puberty. The fact of the matter is, this is scientific, evidence-based treatment. This is work that's supported by every major medical and mental health organization in our country and across the world. And I think I see a lot of misinformation happening lately, saying that some people are walking that back. And that's just simply not the case. These medical organizations recognize that the scientific method is working well with how we evaluate the treatment efficacy for this population. And that is the case for gender identity, as well as any other kind of medical condition. And so we're continually evaluating treatment. But that doesn't mean that it's not safe. We also know that gender affirming care makes trans and gender diverse kids more safe. Why does it do that? Because it reduces depression and lowers odds of suicidality by 73%. 73%. I don't know why we want to do something to help kids if they're at a 73% chance of lowering their odds of suicide. And of course, any medical treatment comes with risks. There's not a single medical intervention out there that doesn't come with risks. And so parents are involved in the process of making that decision, and they should be able to do that with the consent of their each other and full information from their doctor. What about long-term safety? Well, we see that the research, like I said before, research on the safety of these medications are longstanding. We've been using both puberty blockers and hormone treatments to treat a variety of diagnoses for decades. And so these medications are safe. How about the efficacy of gender-affirming medical care? That research is also very well established. We're seeing that research is moving into clinical trials, but it's simply in its infancy. We have only seen clinics that provide this kind of care in the last 10 to 15 years. So naturally, you're not going to have clinical trials unless you're going to have some established clinics providing that treatment. But we do have other kinds of very scientifically valid research that shows that this treatment is efficacious and trustworthy. However, the one thing that isn't safe is banning the care that these children are getting. And one of the reasons why it isn't safe is because it prevents research from happening. So if we say nobody can provide this care, then that also means that researchers can't research that care. And so it's a big prevention of the progress towards affirming trans and gender diverse people broadly. What I like to go into a lot of Mythbusters because there's a lot of misinformation happening out there. And I hope that you'll kind of carry this into your practice with this population. So what are we not doing? We're not providing surgery. We're not doing surgeries on minors in West Virginia. That was one thing that was started in the legislative, one piece of misinformation that was shared. The puberty blockers are not irreversible. We're not going around sterilizing children. There are fertility implications to doing hormone treatment, but those implications are discussed very seriously with parents and their adolescent. And there are fertility saving procedures or dealing with that as they decide to go into hormone treatment. Medical care isn't for pre-puberty children. We just don't operate or do these kinds of things on children before puberty. And again, this isn't provided in secret without parent consent. But there are consequences to banning the medical care for gender diverse adolescents. We see suicide attempts and completions skyrocketing. We do know that 14% of transgender youth in West Virginia attempted suicide in the past year, and 60% seriously considered suicide. So this is a serious business that we're getting into. We also see severe impairment in school domains, health domains, mental health domains. We also see severe psychosocial outcomes in terms of familial relationships and ability to function. And so just, kind of in summary, the consequences are devastating. Trans and gender diverse youth really flourish when they're able to access the gender affirming care that's right for them. And the consequences to banning that care is devastating. Couple more Mythbusters. Hopefully you're not tired of this yet, because I don't think it can be overstated. Gender affirming surgeries only offered to adults. We just don't do that with kids. Medical treatments only offered to adolescents. Puberty blockers are fully reversible, and parental consent is obtained before any medication is given to any patient under the age of 18. So going into detransition. So this is also something that has really become a point of discussion and a point of question, rightly so, because I think as medical providers, they need to be aware of all of the risks that their patients might face when they are agreeing to a medical treatment. And so what we call detransition now is what's considered when someone makes a decision to transition as a transgender or gender diverse person, and then later they decide to reverse that, and they decide, oh, that was not the right decision for me for a variety of reasons, and then they transition back to the gender that they identified with previously. And so there's a lot of misinformation around saying that detransition is just skyrocketing. It's so common now because we're pushing all of this onto children, and it's just not true. Detransition is very rare, especially when children begin their gender journey earlier in life, if they are showing signs of having gender identity concern. And so, I think what we also are concerned about is regret. Do adults regret what they did to receive gender affirming care? And so we see that that is also a very low rate, estimated to be about 3%, 0.3%, sorry, in adults who receive gender affirming care in some form or fashion. And I think that's a really important number, because if you think about regret for other kinds of medical interventions, especially for adults, I don't know about you, but I know there's plenty of times that I've regretted having one or the other kind of medical intervention. And there's, for example, the rate of satisfaction with knee replacement surgery. Regret is very high in that. It also is a very effective treatment, and it's not something that we're banning. So I don't think we should be banning care just because there's a very, very, very slight chance that someone might regret what care they chose to get. So why do people transition? There's been a few studies that are coming to light about why people do. A large majority of them share that it's because the discrimination that they faced while they were transitioning was too overwhelming, or that the stigma that they were experiencing as they were transitioning socially or legally was just too much to bear. Or maybe they just can't afford the medical care. I know I had a friend here recently who moved to West Virginia, had a new healthcare policy that said that he had to start all over again, even though he had been on hormone treatment for 20 years. They said, well, our policy is that you have to have therapy for a year before we'll pay for hormone treatment. And so that person had the means to go out of state and pay out of pocket to get their own care, but that's a decision that should be made between a patient and their doctor. And healthcare policy is also important in this discussion, which we will get to in just a minute. So what does medical gender affirming care look like for adolescents in West Virginia? We have 2 clinics in West Virginia currently for patients under the age of 18. There's one at WVU Medicine that meets once a week, that offers appointments once a week. And then there's one at Marshall University that offers appointments once a month. And that clinic involves a multidisciplinary team. We typically have a adolescent medicine specialist or pediatrician, and these doctors that are providing this care also have loads upon loads of other kinds of fellowships and other kind of board certifications. So the doctors that are providing this care are highly, highly trained. We also have mental health specialists that specialize in the treatment of a variety of mental health issues, and they are well equipped to treat all of the mental health issues that a child may face, including gender dysphoria. We have the legal guardians involved at all times, and that is the team that's evaluating patients that come into those clinics. So what is needed from people like you, people like social workers as well? Non-judgmental support. We know that there's plenty of judgment happening out there for transgender and gender diverse people. And so if you can be a source of non-judgmental support, that is huge. Also know that it's a journey. It's not a destination. Gender identity can be something that people explore, and they're not just necessarily, some people are going to be very sure that they are ready to transition to another gender, and that is the right path for them. So some people need a journey, and so they need you to be on that journey with them. And so what would be great is if you could follow your clients through that process with a non-judgmental stance. Again, that's just something that everybody needs from helping professionals, but especially transgender and gender diverse people. And so if you come across a client that you think might be dealing with a gender identity issue, that's a great time to refer them to a specialist, because specialists can evaluate that patient and their parents and get any kind of treatment to them that's necessary. So moving into legislation and the impacts on gender affirming care. So must a person need to have a diagnosis of gender dysphoria to need gender affirming care? That's an important question, because there's a concern that we're over pathologizing something that's actually quite normal. The World Professional Association of Transgender Health, or WPATH, supports that idea that gender diversity is a matter of diversity. It's not a matter of pathology. We see a variety of gender presentations all over the world and all throughout history. And so if we were to pathologize every single one of those diverse gender presentations, then we'd be pathologizing a lot of people. And so what we really like to say is that gender affirming care does not equal gender dysphoria. For some people it does, and that is a DSM-5 diagnosis in the American Psychiatric Association's Diagnostic and Statistic Manual. But that is not necessarily the case for everyone. Like I said, some people are perfectly happy living in the body that they were assigned at birth, but they just have a different gender presentation or they have a different gender name. So all of those aspects are valid. However, when we get into the area of policy and law, that contradicts this understanding. And that's where it really becomes problematic in the therapeutic sense and in the clinical sense. And so I'm going to talk a bit about what that looks like here in West Virginia, but then also what that looks like in terms of healthcare policy. So here in West Virginia, we have a state code that has been changed. It was changed last year after the passage of House Bill 2007. It's called prohibited practice. And that applies to patients under the age of 18 only. So this does not apply to people over the age of 18 or adults. But this prohibits medical treatment for gender dysphoria unless it is severe gender dysphoria. And so if you can imagine what the problem is that a child needs to convince someone that they are severely dysphoric when maybe they are only moderately dysphoric, but the law forces them to be pathologized in a way that doesn't represent their reality. And so this law becomes disingenuous to everyone. And we've already covered the fact that this medical care is life-saving and safe. And so why are we asking children to fit into a box that doesn't clinically describe them at all? But lo and behold, that's where we are. And so if a child is indeed severely gender dysphoric, then they have access to medical treatment, such as puberty blockers and hormone treatment. So if you're not a medical professional, then what can you do? Like I said, you can refer clients to specialists. That is perfectly legal. You can also continue to provide that supportive counseling. You can provide any kind of counseling, from family therapy, if you're a licensed clinician, to just simply providing that non-judgmental support. This, of course, is not legal advice, so consult your legal representative for legal matters. But I think it's important. People, especially I've noticed that some professionals think that all of the news that they've heard and all of this discussion about things being illegal has really made them step back and not even go to being supportive or non-judgmental of their transgender and gender diverse clients. And that is an unfortunate consequence of this this issue. And so I urge you to not fall into that trap and to continue to be supportive of your transgender and gender diverse clients, because you are perfectly able to do so, and ethically social workers are obligated to. And so that it probably applies to legal matters as well. I'll touch just a brief moment on the health insurance policies that affect gender affirming care. And this comes into play with Medicaid, which I'll explain in a minute. But basically, health insurance policies are dictating when and who should be getting gender affirming care. And like I said before, my example of my friend who was on the treatment and then suddenly had to meet a different criteria for the treatment. So there's kind of two different schools of thought when it comes to how to appropriately assess someone for gender affirming medical care. There's the informed consent model, which is what we use with literally every other medical treatment in our lives, with the very few small exceptions. And then there's also the WPATH standards of care, or SOC. And so the SOC is the document that's been around for a couple decades now, and it's continually updated. And it's basically the document that came out with the idea that there needs to be a letter, or there needs to be some kind of person to sign off on the mental stability of a person before they can get a gender surgery. That was what was happening back 20 plus years ago. But as we've evolved, they have recognized that there's lots of things that trans and gender diverse people go through, including discrimination and stigma. And so they need supportive counseling as they go through their gender journey. But that is also translated into needing to have a letter from a mental health clinician to sign off and say that they are well enough to make this decision. And so, like I said, we don't do that with any other medical condition, with a very few exceptions, such as gastric surgery. But informed consent is what we used for every other kind of medical treatment. For example, you need a surgery, you need ankle surgery. You go in to see your doctor, and your doctor says, well, here's the benefit that you can expect from this. Here's the side effects. Here's the possible risks of failure. And then you get to make your decision based on all of that information that your doctor gave you. And so there are plenty of people that advocate that the informed consent model is an appropriate model for gender affirming care. There is still some tension because the WPATH standards of care are more longstanding for the specific issues of gender identity. But if we take a step back and look at the broader context of medical care, we should not be treating gender affirming care any different from any other medical care. And so obviously I'm a proponent of informed consent, but most health insurance companies are following the WPATH standards of care or other kinds of standards that they come up with. As far as clients who receive Medicaid or are on Medicaid coverage, there's a lawsuit that is currently going into, well, it just recently went through the Fourth Circuit and now is moving on to the Supreme Court, Anderson versus Crouch, which basically argued that the state was excluding care based on this diagnosis of gender dysphoria when it was not excluding care for that same care for other types of diagnoses. And so the ruling so far is that the state cannot exclude that care for those purposes, but it is being appealed. So stay tuned to see what happens. A couple more slides and then we'll be off to questions. It's an important thing to note that the path forward legislatively for people who want to allow people to make their own medical decisions is the Affordable Care Act. Section 1557 is the non-discrimination clause. And so this established law says that we can't discriminate against people on the basis of any of these things. And gender identity is included in that. And so at the end of the day, withholding or banning medical care on the basis of gender identity is simply illegal. And so that is the legislation, that is the law. That's what supports this work. So really quickly, the legislative wrap up in 2024. We saw over 20 bills targeting LGBTQ plus populations. Most of those targeted transgender and gender diverse people in a variety of ways. Only one law became a bill this session, or one bill became law, sorry. So we saw that HB 4233 was signed into law, which amended the code relating to gender markers on birth certificates. And the fact of the matter is, this is an imaginary situation. West Virginia does not offer binary gender markers on birth certificates. And so the legislators decided that they would just go ahead and ban that before it was happening. And so this is reinforced by the fact that the bill sponsor said that he wanted to ensure that the state doesn't start offering the option in the future. So That is the only bill that was passed in 2024. I'm going to wrap up now with just a couple of accounts that I recommend. If you are a social media consumer, these are the Instagram handles of these groups, but you can find them on other social media accounts. These are all groups that I think provide reliable and timely information that impacts transgender and gender diverse people. So that's one way to keep yourself up to date if you're not ready to start pouring through research articles like me. All right, I think I have enough time for some questions. So let's move into that portion. Yeah.
Oh, so go ahead.
No, you're fine.
I was going to just say, again, thank you, Dr. Gandy. That was hugely informative. We'll be taking questions both from online and in the crowd. Again, my name is Caitlin Samuelson. I'm co-chair of the State Bar's LGBTQ plus committee. I just wanted to take one moment to infuse a little more legalese and to give a practice pointer. Again, Dr. Gandy's presentation focused on gender affirming care and not necessarily gender 101. But I know for myself as a practitioner, if I have someone come into my office, a new client, whether they are an individual from Romania, a retired US colonel, or somebody who's transgender or gender diverse, I want to make sure I'm using the right language and have even a minimum understanding of that person's culture. So if people are looking for gender 101, obviously you'll have the written materials from today's presentation on gender affirming care, but the National Center for Transgender Equality, as well as the American Psychological Association and the American Medical Association, have online resources where you can refresh on the terms of gender and sex and the right terms for gender diverse people, as well as transgender individuals who may come into your law office. This is an older statistic, but at one point, West Virginia had the highest rate per capita of transgender and gender diverse youth in our nation. So I know from my brief time as a Rule 10 attorney in WVU's law clinics, yay, that we had a lot of those folks coming in looking for family law care, looking for, hey, I'm in an abuse and neglect situation. I have a foster kiddo who is a transgender kiddo. How do I get them resources? So these folks, if they haven't already come into your office, are maybe going to run into you in the next coming years. And there are resources for you to refresh on your language.
Yeah, definitely. And I want to add in there, I think it's a very pertinent question for family law. And we interface with that as social workers on the DOHS side of things. But we recently had this presentation given to social workers at our state conference, and there's a question about whether or not a child welfare worker whose the state has custody of the child should consent to this medical treatment. And there's lots of discussion around that. And I just encourage you all to take the perspective that this is sound medical treatment, and we wouldn't withhold medical treatment from a child for any other kind of medical condition for which they're suffering. So again, keeping in mind that a child is going to be evaluated by specialists. And I think there's a lot of hesitancy in the child welfare workforce around allowing a child to transition and then possibly facing going back into a family that's not supportive. I think we need to consider the fact that we're withholding life-saving care for a child, and put that as priority, and then help the family understand that this is life-saving care for their child, just like we would with any other kind of medical condition. So just wanted to add that part of issue for the family law folks.
That's hugely helpful. Before we transition into our next two panels, which focus on litigation, BPJ versus West Virginia, and Anderson v. Crouch, questions?
Have you seen any materials on the changes to HIPAA disclosure for gender affirming care and those issues? Have you seen any of that rolling out? There's supposed to be some changes that are rolling out. I just wondered if you've already seen those happening in your practice.
I have not seen that, but I know there's various issues happening with different states and their legislations when it comes to disclosure of private medical information that happens in a clinic, in a clinical setting with a counselor or social worker, and whether or not that information should be disclosed to parents. And that is a very gray ethical area. And so I'm not up to date on the HIPAA side of that because that's more of a federal regulation, but I do know on the state side, there's lots of clinicians that are facing the possibility of legal ramifications if they disclose things that are otherwise meant to be within a confidential setting for a therapeutic treatment. So I don't know, that probably doesn't answer your question because I don't know
I
about
know,
the specific.
I just wanted to see what you're seeing, in your practice. Do you have any idea what the current sort of the boundaries between puberty? Are people reaching puberty earlier these days? What ages are you seeing people reaching puberty? What's the norm?
That's a great question for someone in medical practice. I'm not a medical doctor, so I'm not evaluating kids that are in puberty or going through puberty, but yeah, great question.
I will say in terms of federal regulations, two things our committee is watching really closely and hoping, and maybe teeing up to do a CLE on next year, would be, there's a lot of Title IX discussions happening right now, as well as the definition of gender dysphoria as it relates to the ADA and as it relates to educational regulations. I will also note that in terms of various federal agencies updating language when it comes to non-binary, gender diverse, and transgender individuals. The Bureau for Alcohol, Tobacco, and Firearms actually, as of 2019, 2020, provides a non-binary selection on all of their forms when it comes to purchasing a gun. So even though our states may not recognize these things, the federal government through its agencies are updating, and we're going to see new rules, new regulations, and a lot of litigation related to those in the coming year. So come back to our committee. We'll keep talking about it.
We have some chat questions.
Sure.
Okay.
We can take one.
And I assume this is for Dr. Gandy, but for whomever, I guess. It's actually 3 questions in one. First of all, what is the suicide rate in the trans population?
So it varies, but it's typically, if you're talking about suicide ideation, suicide plan, suicide attempt, and suicide completion, those are all different things. But the range is 40 to 70%, depending on which part of that you're talking about.
Okay. How many surgeries are required to fully transition, if you know?
That depends. Everybody's very different depending on what they want, what their body does in surgery, and what are the outcomes that they're looking for.
Okay. The last question is, what is the average age of surgical transition?
That's a great question. I don't know the answer to it, but I can certainly get back to you, Annie, with that answer.
Okay.
And again, I have all the legislative history here, but we're short on time. And again, under HB 2007, especially as it was passed with some very important amendments from Dr. Tom Takubo on the floor, again, no surgery is allowable until after age 18 in the state of West Virginia.
Just have one more.
Dr. Powell.
You talked about the West Virginia statute that requires a diagnosis of severe gender dysphoria. Is that defined in that statute? Does that deviate from the DSM in terms of the definition of gender dysphoria generally? I was just curious about that.
My understanding is,
I don't have my phone and I was like, oh, I'm gonna look this up.
no, I have a written legislative history about this. So my understanding is severe gender dysphoria is defined therein, as are there also some definitions related to gender and biological sex. But one thing I thought was really interesting about the bill as passed is you can only get pubertal modulating and hormone therapy for severe gender dysphoria as defined, but you need these providers. It's a whole team. You need a trained mental health care provider, an adolescent specialist, the minor's legal guardians, and the minor's primary care physician to all agree that the child has severe gender dysphoria as defined. And I don't have that definition on hand, but it is within the text of the bill. Do you have that definition, Dr. Gandy?
Not on the tip of my brain, but we can certainly get that to you.
With that, I am going to thank Dr. Gandy again. You are a rock star, and thank you for educating all of us here at the State Bar.
Thank you
And
for this opportunity. It's great to talk to everybody. I'm happy to continue the conversation. My email is at the beginning, at the end of the slides, so feel free to reach out.
Thank you. And I'm going to move on to our next presentation
Okay,
and
10
presenter. Oh,
10-minute break, we'll start at 10.
We can take, yeah, we have time to take a, 5 or 6 minute break.
hi, everybody. Are we back? Thank you. I've been told we're back. I have the pleasure of introducing more formally my co-chair of the West Virginia State Bar LGBTQ+ Committee. This is Gerald Langen, Jerry Langen. He mentioned earlier about me putting up with his insane ideas, but truthfully, I think he puts up with mine a lot and the passion we have. I'm so excited for the work the committee is doing, is going to continue doing. Jerry is a retired colonel from the U.S. Army's Judge Advocate General Corps, where he served for 30 years, and we thank him for that. He's also an avid follower of the U.S. Supreme Court. You can find him sometimes hearing oral arguments at the U.S. Supreme Court or at the Fourth Circuit.
I'm streaming right now. There's one box of decisions coming out right now. This means if one big one or a few.
In addition to that, he's been a guest lecturer at Georgetown University School of Management. He has frequently taught at the American Constitution Society on the Constitution in the Classroom program. And he also has his legal degree and undergraduate degree from the University of Idaho and an LLM from Boston University. All of these things combined make him the perfect speaker when it comes to the pending case of BPJ versus West Virginia State Board of Education, which is what he'll be presenting to you all about today. So thank you and welcome, Jared.
Thank you, Caitlin. BPJ versus West Virginia, when we began planning this CLE some months ago, was a case then pending before the Fourth Circuit on April 16th of this year, 2024. A divided panel of the Fourth Circuit Court of Appeals held West Virginia's Save Women's Sports Act impermissibly violative of the non-discrimination provisions of Title IX. Unfortunately, the court's divided panel split between ideological reasons. These issues tend to be very politically driven, and it was kind of a sad reality that the two judges that formed the majority of the court's opinion, Judge Haytens and Judge Harris, were both Democratic appointees, clerks for Justices Ginsburg and Stevens, respectively. Judge Agee in the dissent was an appointee by President Bush. And it's just a sad reality that these cases tend to be politically divided along ideological lines. The case began here in the Southern District of the West Virginia United States District Court before Judge Goodwin in 2021, 3 years ago. Then a 9-year-old transgender girl from Harrison County was at the time competing on the track and field team in her middle school. BPJ, as she's known in the litigation, she's been very public about who she is, and it hasn't been, the media has publicized her name rather widely. But in the litigation, she was always referred to initially by her initials PBJ. And I'll go ahead and just respect that decision and refer to her in that same moniker. But BPJ was a 9-year-old girl. She began a very early transition of her gender care. She fully transitioned beginning in the 3rd grade to the female gender. She has and implemented a gender support plan with the school, which her school administrators, her school faculty, and even her fellow students all gave a great deal of respect to. This was very important because it was part of her gender affirming care prescription that her medical care providers advised. They advised that she begin living her authentic self to the extent completely possible. And one of those suggestions was that she participate fully in events and in activities that involved other girls exclusively. And it was for that reason that she chose to join the girls' track team as at first a cross-country runner. She began running cross-country with the girls' teams, cross-country being a non-contact sport, which we'll see was kind of relevant in the court's decision in striking the law. And she began doing that under the old policy that existed at the time. So West Virginia, the West Virginia Secondary Schools Activities Commission had a formal written policy before the enactment of the Save Women's Sports Act. And that policy provided that transgender students of any sex could join teams that matched their gender identity if and only if two things were met. One, the school made a determination that fair competition would not be jeopardized. And secondly, that a decision was made that the safety of other students participating in the event would similarly not be jeopardized. And so the Harrison County School District, under this old policy, made the decision that fair competition would not be adversely affected by BPJ's participation in the track and field team, and that the health and welfare of competing and fellow athletes would not similarly be jeopardized. And they allowed BPJ to run and participate on that team. And she did so with the full support and acceptance of her teammates and with her opposing athletes, and by all respects appeared to be a very active and participating athlete. In 2021, the Save Women's Sports Act became law, and it worked a sea change on what then could happen. The Save Women's Sports Act basically requires three different things in sports and sports teams in the secondary school and the collegiate level. It requires by law that schools designate a particular sport as either male, female, or co-ed. It must be specifically designated as one of those three things. The law requires that the biological sex determined at birth be the sole indicator that's used in determining the eligibility of the student for participating in that. And that sex assigned at birth, that biological reproductive biology and genetics at birth, be the only factor that can be used to determine whether a student participates. Well, the school administrators in 2021 brought to BPJ's attention that this new law had taken effect and that they were required to remove her from participating on the cross-country team in Harrison County. BPJ decided she would have nothing to do with that, and she decided to bring what's called an as-applied challenge to the Save Women's Sports Act in federal court. So an as-applied challenge is different than a facial or categorical challenge. So a facial or categorical challenge is an entire category of people claim the law impermissibly discriminates against them. BPJ's claim was founded on an as-applied challenge. So as applied to me, as applied to just me, this law violates my equal protection rights and my non-discrimination rights under Title IX. And that was how the claim was brought in the federal court here in the Southern District. And that turns out to be very important in the circuit court's decision. Before Judge Goodwin, BPJ sought an immediate injunction enjoining the state from enforcing the Sports Women's Act because her case was brought as an as-applied challenge to just her. The injunction that the federal court issued was just to her. The law was enjoined from enforcement against BPJ only and was fully enforceable against any and all other transgender students that desire to participate in a secondary or collegiate sport. So it's kind of important to realize that the time the act was passed, there were no known transgender students at the time. There was the legislature didn't know of any such students that were participating. It turns out with the filing of this litigation and the progress of this litigation through the courts so far, there appears to be just a single student who has been caught in this particular prohibition. And that is this now 13-year-old girl. She was 9 when the litigation began, and she's turning 13 now. But the act served to prohibit the record reflects there's only one single person that this act has so far to date actually prohibited from that participation. Judge Goodwin then, of course, enjoined the state from enforcing the act against her. There was a great deal of litigation filed before the district court. There were a significant number of amicus appearances on behalf of both parties. It's very interesting that at the Fourth Circuit, when it finally got appealed to the Fourth Circuit, 119 different amici appeared on behalf of both sides, almost equally divided, 50-some and 60-some on both sides. And again, sadly, the amici that appeared on behalf of both sides seem to fall in these ideological lineups as well in support of the state. There were a number of religious organizations. There were a number of advocacy and family groups. There were a number of what I would call red states that appeared in support of West Virginia's enforcement of this act. And on the other side, in support of BPJ, the plaintiff challenging the law. Most of the major medical associations weighed in support of her challenge to the law. A number of advocacy and athletic organizations appeared, kind of highlighting the importance of sports participation among our youth. And then an almost equal number of what I would call blue states appeared in support of BPJ's challenge. And so this is not a small, insignificant piece of litigation from, sleepy Harrison County, West Virginia. This was a rather significant and big effort at pushing, and it's driven a lot by a number of out-of-state advocates that are pushing really on both sides of the aisle. What we know now will eventually become a petition for certiorari before the United States Supreme Court. So Judge Goodwin began resolving a number of the procedural issues. He enjoined enforcement of the act against BPJ, which allowed her to continue running cross-country team. She at some point later transitioned into track and field and shot put and discus competition while the litigation proceeded. There were a number of expert witnesses and expert reports that were filed with the court. There were a number of Daubert motions filed challenging the sufficiency of the expertise that was filed with the record. And there were summary judgment motions filed on behalf of both sides based on the papers that were filed with the court. Despite the court's preliminary injunction, in which the court recognized the likelihood of success on the merits that the applicant, the petitioner, demonstrated at the outset, the district court's decision was a complete reversal of what seemed to be suggested by the preliminary injunction. Judge Goodwin granted summary judgment on behalf of the state as to both the equal protection claim that was brought by the petitioner, as well as the Title IX claim that was brought by the petitioner, found the act constitutionally enforceable against her and all other students similarly situated, and basically rejected the claim that had been brought by this young girl, transgender girl. Lambda Legal was the primary association that represented her from the outset. The ACLU similarly represented her. They launched an appeal to the Fourth Circuit Court of Appeals. And as I indicated, that argument happened in September of last year. September or October of last year. It was in October of last year, with that decision coming out in April of this year. The Fourth Circuit reversed the district court on the Title IX conclusions, and in fact ordered the district court to enter judgment on behalf of and in favor of PBJ's Title IX claim, finding that the Save Women's Sports Act impermissibly discriminated against her on the basis of both gender and gender identity under Title IX, and remanded back to the district court the issue of the equal protection claims. And the remand back to the district court on those claims was premised principally upon the unresolved issues of the expert reports, basically considering the competitive fairness that might have been presented. So BPJ's experts and the reports that were filed on her behalf said that her commencement of gender affirming care at a very early age in her transition caused very normal physical female development in this child. And the doctor's reports indicate that she evidenced typical bone development, muscle strength, pelvic development, and fat placement of a typical female and of a typical girl. And this medical expert's opinion concluded that because this child had started this transition appropriately at an appropriate time in her transition, that she had no what was called 10 or 2-stage development of puberty, which is basically the onset of testosterone. Testosterone levels that this child presented with were completely consistent with that of other cisgender girls. And this expert's report and opinion, this physician's opinion, was that there could be no competitive disadvantage of other students based on her participation in the sport, largely because this child had developed normal physical traits of a typical cisgender girl. At oral argument, so the state's argument was premised then both on the competitive fairness, the fairness to girls and women in sports activities is something that the state's argument was the largest point that was raised. But in addition to competitive fairness, there was the issue of safety and security of the other competing athletes. And so, and I talked about how this was a unique case from the very outset being brought as an as applied challenge to this child, because this child's sport of choice was a non-contact sport, initially beginning as a cross-country runner, and then eventually transitioning into shot put, track and field events. And at oral argument in the Fourth Circuit, the state conceded that the safety concerns of the other students were not a viable or legitimate concern that the state had in enforcement of this particular act, the Save Women's Sports Act. And so the court realized that we have to then just get back to the issue of competitive fairness. And there were competing expert reports filed on the other side on behalf of the state of West Virginia. Those experts questioned the opinion of the medical experts on behalf of the plaintiff. They suggested that because this child was at birth biologically assigned and born as a male, this expert concluded that you cannot rule out the chance and possibility that there will be unique circumstances, unique physical attributes that this child could develop that would trigger this set of competitive unfairness issues on the track pitch or whatever the athletic venue is. The district court had competing Daubert motions challenging the sufficiency of the expert opinions that had been filed, the expert reports that had been submitted to the court for consideration. And the Fourth Circuit, the majority opinion, was very critical of the district court's failure to resolve those issues below. The judges found that the real question of competitive fairness remains unresolved here on this record. And it was for that reason that the panel, the divided panel, remanded back to the district court the equal protection challenge that was brought to the act for purposes of the district court's resolution of these competing expert opinions that were of the record. And at the appeal, the Fourth Circuit kind of acknowledged that we don't have a complete record on this, and we need that before resolving the constitutional questions. Of course, it's a very typical maxim of the courts that you resolve an issue short of the constitutional questions if you can, and you arrive at the big constitutional questions if and only if you need to under the circumstances, and this panel did exactly that. They resolved it on the statutory Title IX of the Civil Rights Act question, and they saved for a later date the constitutional question of whether or not this law also violates the equal protection rights of the student, and remanded back to the district court on that particular question. So this case is now back at the district court on remand. There's been a flurry of developments since then. The most notable of which I gather would be last month, the state, so as soon as it was remanded back to Judge Goodwin, he promptly entered a scheduling order, setting up some briefing and some arguments to begin like in November. The state moved to stay the scheduling order that Judge Goodwin entered pending the state's petition for certiorari before the Supreme Court. And the state indicated that it was moving to stay that scheduling order until July 15th, 2024, which is the 90-day deadline by which the state must file with the United States Supreme Court its petition for cert. Last week, the court granted the motion to stay the schedule that had been entered in the district court pending the state's promised petition for certiorari to the Supreme Court. So we have rather good reason to believe that this matter is not yet resolved. We have almost a certainty that it will end up going back to the Supreme Court. And I say back to the Supreme Court because there was an interesting development after the appeal to the Fourth Circuit. So during the 18 months that the preliminary injunction by the district court was in place, the state did nothing to interfere with BPJ's participation in her middle school sports teams. On appeal to the Fourth Circuit, there was a renewed effort by BPJ to continue the injunction that the district court had entered, allowing her to participate. The state, of course, opposed that at the appellate court level, and the Fourth Circuit entered a similar injunction, similar preliminary injunction, enjoining further enforcement of the act against this girl, pending resolution of the appeal. The state did kind of an interesting litigation maneuver. They appealed on the emergency docket of the United States Supreme Court, the Fourth Circuit's renewal of the injunction against the state. And they argued before the United States Supreme Court that emergent circumstances required the immediate intervention by the United States Supreme Court to reverse the Fourth Circuit's continuation of that injunction, allowing this one single 12-year-old transgender girl from participating in sports. There was some pretty extensive briefing at the United States Supreme Court level. BPJ's attorneys argued that the emergency docket, the shadow docket of the Supreme Court, is one reserved for national level emergencies that require, immediate intervention by the Supreme Court. That things like stays of execution, which are incredibly critical emergency petitions. Those are the types of petitions that are typically lodged on the docket, the emergency docket of the Supreme Court. And that this particular petition, one seeking to reverse an injunction that had been in effect now for almost 2 years, and that had remained unchallenged by the state for the 18 months during which that injunction had been issued by the district court. The Supreme Court denied in a divided opinion the state's efforts to reverse the Fourth Circuit's injunction, allowing the continued participation on sports teams by BPJ. There was a dissent from the denial of that particular petition. That dissent for denial was written by both Justices Alito and Thomas. Again, sadly, this is an ideological issue, but both Justices Alito and Thomas dissented from the denial of that petition, claiming that this was an issue of such national importance that the Supreme Court should have imposed the injunction on this single 13-year-old, 12-year-old girl, and that the court should take the matter up for consideration. So it's interesting that at least 2 of the justices decided to go on record with respect to, their opinions on the importance of this. And it, I guess, remains to be seen whether those 2 justices on appeal join at least 2 other justices in the grant of certiorari of that case. Of course, it takes 4 justices to grant, 5 justices to decide a case. And so I guess the question is whether two additional Supreme Court justices might join both Thomas and Alito, who have already indicated their inclination, their decisions to take and decide this issue. So we'll see. July 15th is the deadline for the cert petition, and the state has indicated before the district court here in Charleston that there will be a forthcoming petition. Thinking about that for just a second, the Supreme Court generally wants and generally desires, kind of like this appellate panel did, a complete record. So I wonder about the status of the unresolved record from the lower courts. It hasn't been completely resolved at the district court level, and the Fourth Circuit expressly recognized that and remanded it back to correct that record. So it gives me some pause, the timing of it, I'm not sure. Whether the Supreme Court will indeed take that issue or not. Generally, the court wants a complete record. They want it completely resolved and splits in the circuit before deciding a case. So in that respect, I'm not sure. For the state's behalf, the conservative tilt of the court is now primed. I guess if I were representing the state in this action, I would be eager as well to bring this matter to the Supreme Court and bring it now. Because the venue tends to be rather favorable. And there were some suggestions by the state that the lower court, especially the Fourth Circuit, was now an unfavorable forum in which to resolve these issues. The Fourth Circuit has, interestingly, in just the last 10 years or so, transitioned, and particularly during the Obama administration, the composition of the court has really changed. It used to be regarded as one of the most conservative circuits in the nation, and it's kind of slowly evolved into a more moderate, maybe even slightly progressive circuit court of appeals. So it's a really fascinating case. The Title IX conclusions that the court rendered, I thought were really fascinating because the court kind of compared both the discrimination on the basis of gender identity as well as discrimination on the basis of gender. And the court found that a transgender boy, for example, could compete on boys' teams. So Gavin Grimm, so Grimm versus Gloucester County School Board is a Virginia case that the Fourth Circuit held on school accommodations in Title IX. It's typically referred to as the bathroom case. But in Grimm, Gavin Grimm was a transgender boy who the Fourth Circuit held had a right under Title IX to use the bathroom, the boys' bathroom, if that in fact were his choice, and that was. Well, so Gavin Grimm, being a transgender boy, could participate on a boys' sports team under the Save Women's Sports Act here in West Virginia, but only a transgender girl cannot. And the court held this is facial discrimination on the basis of sex. Why is it that one who happened to be assigned female at birth and transitioned to male can play on a male sports team, but one assigned male at birth and transitioned to female cannot play on a girls' sports team? And this was where the appellate panel kind of parsed out the gender and gender identity discrimination factors in the Save Women's Sports Act. I'd like to just kind of turn to and talk a little bit about Judge Agee and his dissenting opinion. Judge Agee in this opinion referred to the majority opinion as a runaway train. He found that the inherent differences in biological males and females required a recognition and enforcement of West Virginia's act. And he was just very critical about how this undermined, the state's ability to regulate this particular field. Lots of words to describe what it was, but his principal point, the principal argument of the state is that segregating sports based on sex is a completely permissible activity. And the courts have all recognized, and even BPJ agrees, segregated sports activities are completely permissible. And in fact, BPJ's argument is that segregated sports activities are not only completely permissible, but that's exactly what I desire because I want to participate in just a girl sport because I identify as a girl. And part of my gender affirming care as prescribed by my providers is that I associate and participate in girls events. And so the segregation of these two sports, BPJ, the challenger to the act, agreed it is completely proper. And the record reflects some kind of interesting things here in West Virginia at this primary, secondary, middle school level. We do not really have co-educational sports activities. It's not until you get to the collegiate level that co-educational intramural activities are common. But within the primary, secondary school systems in West Virginia, all of our sports activities, or the predominant majority of them, are sex segregated sports, and that co-ed opportunities don't really exist, aren't widely available in our state yet. And that was another factor that the majority kind of seized on, that if the state were to be allowed to enforce this act, and BPJ were to require to participate in the boys track team, that act would be subjecting her to the precise harm that the state claims the law is intended to protect. It would subject her to competing against male athletes who have a different bone development and testosterone hormonal development and physical structure, and it would give her the competitive disadvantage in that respect. And then similarly, if it were in a contact sport of any sort, requiring her to participate in a male-only sports activity might subject her to the risk of harm and safety that the state claims the act is intended to protect among all students. And so the majority was somewhat critical of the state's arguments there. Judge Agee, in his dissent, I just thought the conclusion of his dissenting opinion was quite striking. His very last sentence of his dissenting opinion says, "One can only hope that the Supreme Court will take the opportunity with all deliberate speed to resolve these questions of national importance." And I believe our state is primed to come through with Judge Agee's clarion call to bring this matter to the United States Supreme Court. And whether the court exercises that deliberate speed to resolve these questions, I don't know. But just in terms of timing, I would suspect that Petition will be filed this summer. Some briefing at the Supreme Court level will occur summer and fall. We may have a decision when the court opens its term in October. It might be later, I don't know, but the chance that this case eventually is to be considered by the Supreme Court. I would guess we will know by the end of the year. Of course, what will happen, I don't know. That's once it gets to the Supreme Court, it will again attract a huge national influence on both sides. The 119 amici that appeared at the Fourth Circuit, I'm sure, will all be back at the Supreme Court on both sides of this issue, advocating again those respective positions. And with that, I think we may have 10 minutes for any questions if there are. Questions here in the audience first, and then we can go to online questions.
Is there anything else bubbling up at the Supreme Court that's gonna like, sort of, we get pulled into this together, so it could muddy the water or make it a little different as far as Title IX?
So on Monday, the Supreme Court granted certiorari in the Scrimeti decision. So the Scrimeti decision is the gender affirming care ban of the state of Tennessee. Tennessee banned all such care, and the court on Monday announced that it will be hearing next term that appeal. So we know that case is going to be argued. That's Tennessee next door here. The Biden administration rolled out some new Title IX regulations. And just last week and the week before, federal judges in Kentucky and somewhere else, the Fifth Circuit, enjoined enforcement of the new Title IX regulations. That dispute is not over. And those cases are also very relevant to this because the Title IX decision of the Fourth Circuit is right now the only real decision that the Fourth Circuit has rendered. They didn't opine yet on the equal protection claim that was brought. So these other Title IX challenges that have these were just last week. The Kentucky case came out. Those will bubble up. There will be a lot of other activity. And I expect that there will probably be emergency petitions on those Title IX challenges with respect to the educational regulations that were just rolled out a month ago.
Jerry, as a procedural matter, can you think of any other cases where you've had pending or unresolved Joubert-Kumo motions on the record and the Supreme Court heard it and addressed the case on the merits? I think maybe Washington versus Crawford, which was ultimately about testimony and confrontation clause, maybe had some Daubert stuff pending, but can you think of any cases?
Not specific cases, but I've just noticed that when the court wants to hear and decide something and they want to do it quickly, the Supreme Court can and does. And when they want to kind of slow roll something, they can do that as well. And so I think, and there's just some interesting dynamic on the Supreme Court now with the new conservative majority, Chief Justice Roberts. It just, all signs seem to suggest that he's trying to exercise some civility and some care and caution in how the court proceeds, and he's outnumbered on the right flank in his ability to do that. And the conservative justices are moving these things forward. So I don't know, that my only observation is that when the court wants to take something and decide it, they can do, especially on the emergency docket. We see a lot of that.
Well, I'll say as a member of the Harrison County Bar Association that if you ask anyone in Clarksburg, they will tell you, according to Jimbo Fisher, that sports are a matter of national security and are highly important.
Sports are important from a personal development perspective. I mean, I'm a runner. That's one of the things I've been a runner for a long time. I've run 17 marathons, and that's kind of an important piece of who I am. And sports has instilled in me just a sense of ethic and a sense of character and a sense of, being, it's a very important thing. And especially for, grade school, secondary school, high school students. I mean, sports are really important. And that's why our school systems promote and encourage and advocate those types of things. I mean, it's just really important, and I just think it's sad when we try to eliminate that avenue of personal growth that young people can pursue.
Do we have any online questions?
No, not enough.
Okay.
Right.
Any other from the community here in person? With that, I suppose we're slated for another small break before we proceed to our third panel.
10 minutes.
10 minutes. Thank you all so much. Wonderful. Thank you, everyone, for your patience as we resolved a technical issue, as well as just being back here with us. I am honored to present our next two speakers. One is local counsel, and then one is counsel from Lambda Legal, who will be presenting about Anderson v. Crouch. To give a little context here of who our two speakers are, local counsel is Walt Allville. He is my esteemed colleague across the bench in numerous employment law matters. Walt hails from Parkersburg, West Virginia, where you'll find the Employment Law Center, where he practices with his son, Kirk Allville. Walt has made numerous contributions in the state of West Virginia in the realm of employment law, including founding the West Virginia Employment Lawyers Association, which is a state affiliate of the National Employment Lawyers Association. He has edited the Employment Advocate, the state association newsletter, for over 15 years. Walt was previously on the West Virginia Education and State Employees Grievance Board, serving as the board's chairman from 2003 to 2004. He is a member of the board of directors of Workplace Fairness. He's also authored and edited numerous articles as it relates to employment law in the state of West Virginia. And I'm so privileged to call him a colleague. We also have from Lambda Legal, which is our nation's oldest and largest legal organization committed to effectuating and enforcing the rights of LGBTQ plus Americans. We have Tara Borelli. Tara's work really centers on bringing test cases to advance issues such as marriage equality, LGBTQ plus rights, and equality and liberty for all LGBTQ plus people. Some of the cases that she's served as lead counsel on include Caudle versus Falwell, which was a case challenging the North Carolina State Employee Health Plan, which excluded gender affirming care for transgender folks. Tara, which has represented numerous transgender people in cases seeking equality, such as equality to access in military service. That would be the Karnofsky versus Trump case. Medically necessary care for minors. That's Skermetti, which Jerry mentioned earlier is going up to the Supreme Court. School facility cases and athletics cases. Tara previously brought challenges to the Federal Defense of Marriage Act in Galinsky versus U.S. Office of Personnel Management. And she also was integral in arguing Sevchik versus Sandoval before the Ninth Circuit, which was a case securing marriage equality that later led up to Obergefell v. Hodges, which today is the anniversary of that decision before the Supreme Court. 9 years, as Jerry adds. Tara today will be speaking and educating us on Anderson versus Crouch, which was a challenge to exclusions under West Virginia Medicaid, which Dr. Gandy mentioned earlier. The Fourth Circuit recently ruled en banc, finding that exclusions violate federal law. And I'm going to flip it over to Tara Borelli.
Thanks so much. Really a pleasure and an honor to be with all of you, and I truly appreciate the invitation. We are sorry that my partner in crime, Walt, hasn't been able to join yet because of technical issues. So I'm hoping we'll be able to get him in because it will certainly be more fun for all of us. That's always true when Walt is around. But at any rate, I'm very grateful to have a chance to address all of you and talk about this case, which has been a real labor of love for some time now. So let me start off with a few just preliminary comments to kind of situate the scope of what I'll be talking about today. I'm a counsel in this case, and of course, litigation remains ongoing. And so obviously we intend to preserve and are preserving all applicable protections and privileges, attorney-client product, and are not waiving any of them by participating today. And that may mean that, for example, when we reach the Q&A portion of this, there might be certain questions that I will defer on answering to the extent that they might call for confidential thinking or strategy. But what I will be doing is talking at a higher level of generality about this case and talking about generally public information about it. So no state secrets today, unfortunately. But I also want to share that, you know, I come to this work as an advocate. So I have been counsel for a number of years with Lambda Legal. We don't need to say how many. You know, Lambda Legal is the oldest and largest organization fighting in courts for equality and freedom for LGBT people and everybody living with HIV. And so that means that we have a particular viewpoint on this work, which is advocating for equal treatment unapologetically. So that said, I want to just emphasize that lots of people of goodwill come to these topics in these cases with honest, genuine questions. And particularly when we get to the end, I'm going to work to reserve some time for questions. And I want people to feel welcome to ask them, even if you might feel like you're newer to this topic, because I think it's so important that we be engaging each other across information divides. And so I'm certainly very eager to do that. So what I'd like to do is actually start with the very big news from a couple of days ago, and Jerry, of course, touched on this, and that was the grant of cert in the Scrimetti case. And I'll talk a little bit about some of the nuances of it, because there are just some interesting sort of contours to what the Supreme Court did in granting cert. And I can talk a little bit about how that area of litigation then intersects with this case, the Anderson case. So the Scrimetti case is a case involving ACLU, Lambda Legal, and the law firm of Aiken Gump, which has just done extraordinary work on that case with us. And this was a challenge to the ban passed by Tennessee on gender affirming care for transgender adolescents. We're now in a deeply sort of terrible state of affairs in terms of equal access to urgently needed medical care, which is that at least 25 states, and the number might be higher, have now passed bans similar to the one that Tennessee did. The 6th, the 7th, and the 11th Circuit Court of Appeals have all allowed these bans to take effect. And that generally happened after deep engagement by the trial courts with an evidentiary record that set out quite a bit of the information that you heard in the first session today. So there's extensive expert testimony to help the courts understand the well-established standards of care, the decades of science supporting them, the broad literature, evidence base supporting this care, and the medical consensus among experts in the field and every major medical and behavioral health organization in the United States, all of which recognize the diagnosis of gender dysphoria, the standards of care as the prevailing standard of care in this field of treatment. And so after a number of district courts looked at that science and grappled with the evidentiary record, by and large, they tended to find that these laws were unjustified as a matter of law and needed to be preliminarily enjoined. then with some disappointing results that I just highlighted. Oh, wonderful. I'm so glad that Walt has just joined us. Welcome, Walt. So Walt, for your benefit, I have just started out with the first question that we had identified for today. So I'm just doing some talking about the Supreme Court grant and situating that relative to Anderson. Please go ahead if you want to say hello, though.
Howdy. I'm good.
Fantastic.
A little tech issue, but we're good to go now.
Thank you. We're so glad you could join us. So there's been, with all of these bills passed, all of this targeting of trans youth healthcare in these legislatures, all of these bad bills passed. Of course, as you can tell from the different district courts and circuit courts I'm mentioning, there was just an extraordinary amount of activity in the courts challenging these bans. That then resulted in the first set of petitions up to the Supreme Court seeking review came from this Tennessee case that we filed, a parallel challenge to a gender affirming care ban in Kentucky, that case by National Center for Lesbian Rights and GLAAD, and then the United States, which intervened in our case in Tennessee to participate as a party in that case. And so the United States also filed its own cert petition. The Supreme Court granted cert to the United States and took no action on the other petitions. So what does that mean? So the Kentucky case hasn't been taken up because no action on that petition. Those of us who brought the Tennessee litigation, our respondents were participants in the case that the Supreme Court has granted cert to. But because the court acted on the petition by the United States, that means that the court has limited the question it will review to the singular question that was presented in that cert petition, which was an equal protection question. Much of this litigation has involved arguments and rulings on due process rights of parents to control the custody, care, and medical treatment of their children. But because of the way that the court granted cert here, its review will be limited to the equal protection question. So in terms of the timing, of course, as soon as cert was granted, that triggered a briefing schedule, which will happen fairly rapidly. I think that it will be fully briefed by roughly October 9th. And we anticipate that the course would be argued likely November or December, just based on the court's kind of ordinarily scheduling protocols. That case is different in some ways from the Anderson case that we're going to focus on today. It involves an absolute ban on care and focuses, of course, on adolescents, whereas the kind of major factual context for the Anderson case was discrimination in coverage and whether that kind of discrimination is permitted in a health insurance plan or, as relevant here, a Medicaid plan. Interestingly, fewer cases have actually reached the courts of appeals on the posture of Anderson in cases involving discrimination in coverage. And there is another case in the 11th Circuit that recently resulted in a win for the plaintiffs there who challenged a ban on gender affirming surgery. But it looks like there may be further review in the 11th Circuit since there's been a petition for rehearing en banc. So I'll sort of wrap up there in terms of how to situate this relative to what the Supreme Court just did. And while
Kara, could you talk a little bit about the procedural history of this Anderson case, and particularly the, for lack of a better word, dramatic developments in the Fourth Circuit?
Sure. So this procedural history is maybe a little bit more interesting than some others. So the Anderson case is a challenge to the exclusion for gender affirming surgery in the West Virginia Medicaid program. Medicaid is, of course, as folks know, it's a joint federal state program providing health insurance to people who have low income. States are not required to participate in Medicaid, but all of them do. And once a state opts to participate, it has to meet the minimum requirements of the Medicaid Act. And those stand as a really important bulwark in terms of ensuring access to essential care through Medicaid programs. And then, of course, as a government actor, the state has to comply with the Equal Protection Clause and is also subject to the Affordable Care Act protections against sex discrimination. This case originally included a challenge to the state employee health plan, which also had exclusions for gender affirming care. And so it was, different plaintiffs and different defendants, but with common legal questions. And so joined together in this case to try to resolve those legal issues efficiently. The early litigation on the state employee claims resulted in a settlement that now makes access to gender affirming care available through at least one state employee health plan, which was a very gratifying outcome for us. And so after that, the case shifted and has had a complete focus on the exclusion in the Medicaid program. We did also seek and receive certification of this case as a class action, and that is going to become an increasing area of focus, I think, for people seeking, not just in the context of these cases, but in a range of civil rights and plaintiff side cases, to expand relief. The Supreme Court has recently gotten interested in the scope of injunctions and when it is appropriate to enjoin enforcement of a law beyond the named plaintiffs, which has a particular importance at the preliminary injunction stage in terms of the doctrine. So we knew that the exclusion in this plan was affecting many, many, many people and were wreaking havoc on them, and thought that this was a very good candidate to be certified to ensure that the legal question, which in and of itself shouldn't vary from participant to participant, could be resolved in a way that would get everybody who was affected by the exclusion relief. And the court agreed, trial court agreed and certified the class, and the en banc court held it. What made this sort of interesting is we had a parallel case that we were litigating in North Carolina, where the state employee health plan also excluded care. That plan has some different contours. And so I'll talk at different points during this hour about there's one particular factual record in West Virginia, but if you change that factual record, it doesn't actually change the answer or the outcome, because the legal issues are clear no matter what the variation or the stripe of discrimination is as between the two scenarios here. So that case just coincidentally was on a parallel track. Both reached the Fourth Circuit at approximately the same time, but they were argued to different three-judge panels. And then the court sua sponte ordered that the cases be reheard en banc. And obviously it doesn't provide an explanation when it issues that kind of order, but we can presume that the court wanted to ensure consistent treatment between the two cases, which would certainly be indicated by the fact that this Anderson opinion is actually just part and parcel of the Cadle opinion as well. So the cases were not formally consolidated, but the court issued one opinion, and in that opinion resolved the issues in both cases because of their similarity and their overlap.
Hey, Tara, can I just interrupt and ask a question real quickly?
Of course, that's why you're here.
Have you ever heard of or been part of a sua sponte rehearing en banc? Because I've never heard of it. I've never heard of it happening. No motion.
I can't say that it's happened in my personal experience. Perhaps others who are participating have had some experience with it. I imagine it must have happened previously, but it was certainly new to me. We were delighted not to have to rebrief the issues. However, the court accepted the existing briefing, and so we were glad to see that the court felt that the initial treatment of the issues seemed to be sufficient to be able to weigh in at the en banc stage.
So could you talk a little bit about the evidentiary record in this case in West Virginia, and how, from your perspective, that shaped both the district court and the en banc opinion? Because I think that's one of the most interesting parts of the case in a way, and particularly interesting more in what the record doesn't have than in what it does have. And I'd be curious to know your thoughts on that.
Yes. So, you know, when the analysis is properly done, because of course, one of the primary claims here was equal protection, the record is really important. So for those of you who aren't litigating constitutional claims every day, this might take you back to your bar courses. But as folks will recall, when you have heightened scrutiny, and that's where a lot of the heat was in this case, what is the appropriate way to view the classification here, and does heightened scrutiny apply? The court ultimately decided that it did. Under that standard, of course, it is the government's burden to show a justification. That justification has to actually have motivated the classification. So it's obviously very different from rational basis, which generally looks at any conceivable government interest, anything that the government can think of can be examined and proffered under rational basis. But under heightened scrutiny, there really has to be a showing that the justification being offered actually motivated the classification here. And then, of course, the tailoring is also very important as well. Whatever governmental interest is being offered, that classification has to be substantially related to it. So you can't have a government interest where this classification actually doesn't do anything to serve it. And so I think both of those issues, were a key part of the court's analysis. I thought it was really significant here that the Medicaid program covers all forms of gender-affirming care for participants, with the exception of surgery. So the health plan covers counseling, office visits, hormone therapy, lab work, but just arbitrarily draws the line with a blanket exclusion of surgery, regardless of medical necessity. The state contracts with a medical utilization company, which relies on nationally accredited standards. And under the standards, which were produced in discovery, of course, surgery to treat gender dysphoria is considered medically necessary. It's part of the standard of care. And these sort of neutral, nationally accredited guidelines recognize that in a very clear way, because again, the sort of consensus among clinicians, practitioners, and experts in the field is clear and really has been for quite some time. So when we got into discovery about the exclusion and the adoption of it and what motivated it and what could the state show in terms of actual motivations for it, the government admitted that it was adopted around 2004. I don't believe they knew exactly when it was adopted. They don't know why it was adopted. They admitted they didn't know what information, if any, was relied on when it was adopted. And so I think that's just critical, because it again goes to that point about you got to show an actual motivation, and you got to show that that motivation actually was the motivation. And so the admissions really were, we can't produce any. And so everything that was proffered was really offered for purposes of litigation, which isn't sufficient under heightened scrutiny. The opinions, I think, still, at the trial court and at the en banc still examined those justifications. But I think that was just a critical piece of showing that, whether the motivation being offered was genuine, just the evidence was too weak to sustain that interest. Another thing that was really critical is we spent some time really probing on the issue of cost, because that was one of the justifications offered for the exclusion. And the state admitted, of course, that they hadn't conducted any research or analysis about the cost. We had expert testimony that the cost of this care, particularly in group health plans, is infinitesimal. It barely registers. Generally speaking, when this coverage is added in a group health plan, it doesn't, we're talking about a plan with premiums. It doesn't result in any increase in premiums because of how low cost the care is. Transgender people are a proportionally small part of the population. There's nothing disproportionately costly about receiving the very same medical treatment that is covered for cisgender people. And that's really what the case was about. Cisgender people receive these treatments, they receive this care. Transgender people are simply seeking access to the very same forms of treatments. And so it was really significant that when the state proffered cost as an interest, they weren't able to point to any particular research consideration or analysis of that cost. And so the record really then reflected our expert testimony showing that it simply doesn't even register on the Richter scale. And I'll mention one other piece of deposition testimony. It wasn't mentioned in the en banc opinion, but it was something that we thought was significant. The program used to exclude coverage for hormone therapy. And at a certain point, they made a determination that they would begin covering that. And the testimony, and I'm paraphrasing here, of course, but the testimony was to the effect of, we were hearing from people who were just in anguish over not being able to secure access to this treatment. And so we acted to cover it. Really, it was an act of compassion, was the testimony. And the follow-up question, of course, was, why didn't that compassion extend to surgical care? And the answer was, I don't know. This was a 30B6 deposition. And I think that testimony kind of encapsulates the state of the record. And so we thought that was sort of a powerful metaphor for what the case looked like after probing all of these evidentiary issues in discovery.
And you mentioned the Fourth Circuit opinion, Tara. Could you hit some of the highlights of this War and Peace length tome that was issued by the Fourth Circuit and the dissents as well? Because just the, you can do the cliff notes for the highlights here, but it's quite a lengthy exploration of a variety of issues, to put it mildly.
Yes, absolutely. So I think as was mentioned earlier, we certainly weren't writing on a blank slate here. So the Gavin Grimm case, which was the first federal challenge involving a transgender young person seeking equal access to facilities, specifically the restroom at his school, that was just an incredibly important decision, ruling that heightened scrutiny applies to trans status classifications, and also that discriminating against transgender people as a matter of equal protection and Title IX is sex discrimination and requires heightened scrutiny for that additional reason. There's also a really important ADA case, Americans with Disabilities Act case, Williams versus Kincaid, and it was brought by a woman who sought healthcare while she was incarcerated under the ADA, and the court was looking at language of the ADA to determine whether it had an exclusion of coverage or protection, I should say, for transgender people. And the court said, as a matter of constitutional avoidance, discriminating based on gender dysphoria, if the statute did that, that would create a constitutional problem, because that would be to discriminate against transgender people as a class. And so we construe the statute to avoid that problem. And so that was a really important precursor, recognizing that discriminating based on gender dysphoria is discrimination against trans people as a class. So just in terms of, I'll go back to something I mentioned a little bit earlier, which was a lot of the heat in this case was around what's the appropriate classification. And the government, of course, argued that, well, this is diagnosis discrimination, and therefore that receives rational basis. It's not transgender status discrimination, not sex discrimination. But of course, we've got that Williams versus Kincaid opinion, which kind of previewed this analysis of, even if it were diagnosis discrimination, and the exclusions in this case, they don't reference the diagnosis, but even if it were, that is discrimination against transgender people as a class, because this diagnosis, it is inextricably linked with what it means to be transgender. So I think there's a lot of really important discussion about proxy discrimination in this case. And one of the reasons that I think the court took such care to talk about that, so to talk about the exclusions. So let me say what the exclusions were in the plan. They were phrased a few different ways. One of them was no coverage for transsexual surgery. And I do apologize, I'm quoting the exclusions here, but they use quite outmoded language that is considered offensive in today's terms. But transsexual surgery and sex transformation surgery, again, a very outmoded term that no clinician or expert would ever use, but it does make very plain what the intention is here. It's right on the face of that exclusion. I think if you were to pull an average person off the street and read them those exclusions and say, do you think that's about transgender people? I think the average person would say, of course it is. But we spent a lot of time fighting about that, and the court spent a lot of time talking about it, I think in particular because of some spillover from.
And Tara,
Yes.
and yet at least some members of the Fourth Circuit didn't seem to be able to perceive that.
That's a very fair point, duly noted. So this next piece, I think the reason there was such lengthy discussion about proxy discrimination is because of the spillover effects of what's happening around abortion care in the courts, and in particular Dobbs, which overturned Roe versus Wade. So there was a quite older decision from the 1970s called Geduldig, which asked whether discriminating based on pregnancy status is really the same thing as sex. And the court said, no, that's not closely tied enough to sex to serve as a proxy for sex discrimination. And the court hadn't touched that precedent for decades. And then they cited it again in Dobbs as a way of saying, and also a restriction on access to abortion care is also not sex discrimination. And so that became a really key feature of these cases to, where this really is true, not just uniquely in this case, but is something that we are generally arguing about in all of our cases of access to gender affirming care. The argument from the other side often has a few different stripes. One is, well, this just means, there can be no sex discrimination found in healthcare any longer. Another stripe is, well, this just tells us that if you single out one group for discrimination, it's just not sex discrimination. And I think the court, of course, did such a masterful job saying, no, even if we look at this as proxy discrimination, the Supreme Court hasn't eliminated that or overturned that. It has simply said that this one particular proxy is not closely aligned enough with sex to be treated as an automatic proxy for sex. That doesn't tell us anything about something like gender dysphoria, which again is inextricably linked to transgender people and is literally about how we understand a person's sex. You can't say the phrase gender dysphoria without referencing sex. You can't describe, and this will sound familiar, some of you may recognize this from Bostock, you can't say what gender dysphoria is. You can't say what a transgender person is. You can't answer the question of whether the care would be covered here without knowing a person's sex. You have to answer that question in order to say whether it's covered, because for cisgender person, this care would be covered. But if your gender doesn't match your sex assigned at birth, the care is barred. And there's simply no way to make those decisions without referencing sex. And the Supreme Court has told us that is indeed sex discrimination. It is also transgender status discrimination and requires heightened scrutiny for both reasons. So, there's another much more direct way, of course, to resolve this case. And one of the things that I think is quite helpful about the opinion, I think maybe perhaps in recognition that there may be further review of it, or at least attempts to ask the Supreme Court to engage in further review. And so the opinion provides this very fulsome treatment of all of the different arguments and the claims raised. And so, of course, a very straightforward argument that we had made, the court also agreed with, was just on its face. You don't even have to engage in any proxy analysis. Something that says no coverage for sex transformation is about sex, as a classification based on sex. And I also think it's very helpful that the court discussed an additional theory that we raised, which was about stereotyping, because I really think that that's quite prevalent in exclusions like this, where one of the arguments that the other side had made was, we just don't provide gender affirming care to anybody. And the court said that that's just not true. By the terms of your own plan, if a cisgender woman requires a vaginoplasty, that care is covered, and that care is affirming of her gender. And the only time that that care is excluded when it's required to affirm someone's gender is for a transgender person. That is sex discrimination. That is transgender status discrimination.
Jerry, you've covered a lot of the I'd say details of the case, but can you talk just a little bit about representing transgender clients in the context of this and other litigation and what challenges that poses as an attorney representing folks who are challenging these type of issues?
Absolutely, and it's something that's just on our mind all the time. I never imagined a few years ago that the environment would get as bad, as hostile as it is currently towards transgender people. When we look at the amount of legislative activity across the country targeting transgender people across every domain, every aspect of life. So many, many, many bills targeting the right to access essential health care, but also, you know, don't say gay or trans bills in schools, really trying to erase the existence and the visibility, just the basic existence of gay and transgender people. Bans on equal participation in athletics, which can be so important for all kids, including transgender kids, for the reasons that Jerry was describing. And there's just virtually no ID documents. We're seeing a bunch of bills, ban access to correct ID documents, access to facilities, access to restrooms. It's really, really hard to get through a day of school without being able to go to the bathroom. And so it's painful to have watched this sort of just unbelievable curve. If you were to look at the curve of sort of bills targeting LGBT people, I mean, attacks on LGBT people have been around for a long time, but the sheer volume of what we have seen in the last several years is unparalleled. And we're talking like over 500 bills a year nationally. It is a really frightening time to be a plaintiff in cases like this. And I'm just talking, generally speaking, writ large about kind of our cases overall across the country. Many of these cases about access to healthcare for adolescents, these really, really brave families who've stepped forward to challenge these laws, have had to seek, protection to proceed under pseudonym, because the risk of death threats and targeting at their homes, just given the state of the internet, everybody is so findable these days. So if you look at these cases, actually, if you were to pull up a list of these cases, you would notice that there are a variety of variations on Jane Doe, Doe, Vo, Po, Lo, and a lot of that is because just for their own basic protection, these plaintiffs have had to seek to proceed under pseudonym. And I'm not aware of a single court that has actually denied that protection yet, which I think is also kind of a further recognition by the courts of the sort of moment that we're living in. It doesn't just affect plaintiffs, though. Dating back now several years, where when some of this sort of hysteria started getting whipped up around access to trans healthcare, we saw children's hospitals who offer this treatment as just a regular part of the care that they offer to adolescents, get bomb threats. And once that started, our experts started finding themselves receiving death threats. We had a trial recently about another Medicaid case in Florida, and we had to hire armed security to transport our experts and witnesses to and from the courthouse. We've never had to do anything like that before. And we've had to take extra steps to protect transgender employees, to sort of services that help erase their findability on the internet, because we have seen too many visible trans lawyers get doxxed and receive death threats. So I don't mean to be so grim and so dark, but it's a really challenging time right now to do this work, and it makes us extra grateful for the plaintiffs and the experts who are willing to step forward and to be so brave and to make sure that these attacks don't go unchallenged. And it makes me very grateful that they will have their day in court, several of these plaintiffs, when the Supreme Court does hear the case, because when people sacrifice so much to be part of these cases, they really deserve to be heard, at least.
I'd also note it's not unusual in a lot of the employment cases I do to see pretty tough depositions, but the depositions in this case were pretty grueling. I'll just say that. And of course, as a bar, we should all be concerned about the threats to participants in the legal process and the threat that that poses to the rule of law, just generally, regardless of the particular issue. But I saw that we have a good number of questions that came in online, and I'm sure we have questions from the audience as well. So I'll shut up and for those.
I have a question for Tara, just to make sure I understand the record as we advance forward. Looking at the joint appendix and looking at the opinion itself, it wasn't clear to me. Did the state appellates concede or agree in any way that gender affirming care for cisgender individuals, like breast augmentation, uterine ablation, or reconstructive surgery after testicular cancer, they didn't agree that those things would be equally covered under the plan as gender affirming care?
So it was undisputed that the procedures, what would, that there were parallels, that the care that the plaintiffs were seeking here is covered for certain diagnoses for cisgender people. But no concession that some of those purposes are gender affirming for cisgender people. So that was really the sort of, I think, indisputably correct observation of the en banc court. But we did have, clarity in the record that these plaintiffs were seeking access to procedures that, without question, were covered for cisgender people in other circumstances.
So the coverage is undisputed, but characterizing it as gender affirming care for cisgender folks versus gender diverse folks, that's what's debatable, according to the state appellates.
Yes, I think that would be one of their areas of disagreement. Yes.
Okay.
Two questions online. The first one is, have you seen any case activity related to transgender discrimination within the context of Title IX actions? If so, are the courts using the law from these contexts to help formulate their opinions?
Great question. One of the major issues, and I actually think the Supreme Court may weigh in on this in the case that it just granted cert on, is we of course have the court's wonderful opinion in Bostock, which interprets Title VII to say discriminating against transgender people and gay people is sex discrimination. There's no way, if you're discriminating on that basis, you are necessarily discriminating based on sex. And so there's obviously been great opposition and disagreement on the other sides of these cases to application of that reasoning to other contexts, whether it's equal protection or Title IX. Here in the Fourth Circuit, the court has for a very long time interpreted Title VII and Title IX in parallel because of the many parallels between the two statutes. And I think it's now clear also that that same mode of analysis about how to understand sex discrimination applies to equal protection as well. There's nothing that's sort of uniquely different or less protective about how to understand sex discrimination in this context. But that is a major source of disagreement because, of course, the reasoning in the Bostock opinion is, we think, makes quite clear that singling trans people out for discrimination equals sex discrimination.
And then the next question is, what is the difference between a cisgender person and a transgender person?
So thank you. I appreciate that and realize I should be careful about using jargon. So cisgender is simply a way that a term that's come to be adopted to refer to people who are not transgender. So transgender and cisgender meaning folks who are not trans. So that's really the distinction between the two. And I do see just one additional comment in the chat, at least, that it's really devastating to be the parent of a transgender teen at the moment. And I just can't agree enough. I mean, we have litigation in Texas, among many other places, where the state of Texas rushed to issue an executive order requiring that getting access to this essential, well-established medical care for your child, your adolescent, be treated as child abuse, and that families be investigated for child abuse, with the risk of having their children removed from their home and from their custody, among many other forms of attacks on this care. Not all restrictions are quite that egregious, but some of them, are felony bans on getting access to this care. Some of them instead impose the penalties on the providers who can no longer provide this care without mandatory loss of their licensure if they do so in violation of the terms of the statute. And just the human misery and suffering of watching families struggle as the sort of lights got turned off state after state in the South. And so the states that people were fleeing to get care then adopted bans. And the amount of money that it takes to be able to travel to access this care, it creates issues for families about accessing care out of network potentially, which is also financially devastating. People have to miss work. Kids have to miss school in order to get this care. Creates childcare issues for their other kids. I mean, just at a human, practical, logistical level, there's just such suffering that these laws impose, which is another reason that I think we just had this feeling that we could not keep going the way things have been with the number of states where these laws have been allowed to take effect. So I, again, am quite glad that the Supreme Court has taken up this issue, because we're at a crisis point for families, and we need an answer about whether the Constitution allows this kind of punitive action to be taken by states towards these families.
If I could just hop in just 1 second to say something more generally about this too, as local counsel in this thing, I just wanted to note that if it wasn't for organizations like Lambda and ACLU and some other organizations to take these cases, people would have no representation in general. And I can't say enough about the work that those organizations, Lambda and ACLU and other organizations that have taken these on have done for these families and individuals, because it's far beyond what a private practitioner, at least in our area, would mostly handle. So just wanted to throw that 2 cents in there too.
Thank you for those kind words. We certainly couldn't do it without excellent local counsel like Walt.
Well, thank you both. Thank you all so much for joining us today. This has been highly educational for me, and I'm so grateful for our speakers.
Thank you, Chair.
With that, have a beautiful day. It's a beautiful day to litigate.
Job security.